the attorney didn't get that the family didn't want to go through it because they were so used to going through the court process. But why would you put a family through that? Hi, Jeff Marsace, the Plain English Attorney, and welcome to today's video. We're going to talk about why avoid probate. This question sometimes comes up when people are initially making their searches. They're not necessarily understanding what probate is. So this is actually a reaction video to a Reddit thread asking that very question. So let's go ahead and jump into it. Why avoid probate? I've always heard how preferable it is to avoid probate, but I've never gotten the full details on why. My assumption is that it's time intensive and expensive as well. Time intensive I get, but for expensive, if the alternative is a trust, doesn't that have associated costs that even out? Just trying to get the best sense of why people avoid probate when they can, because I'm considering options in my own estate planning and don't want to just knee-jerk away from probate. Well, okay, so that's some legitimate question, weighing the pros and cons, and that's what I end up telling my clients all the time. I can lay out all the facts. Here's what a trust does. Here's what a will does. Here's what probate is about. The will means probate. Here's how that estate's coordinated. If you got a trust, there's coordination on this end. You've got to weigh the pros and cons for your situation. So let's continue. In my own case, I live out of state from all my relatives except for my own minor child. Seems like that would be one reason to avoid probate. But anyone who would benefit from my death financially, except the kid, also has substantial means and wouldn't need the money if probate took a while, even if they had to provide for my minor child for a good bit. Edit. Oh, and to add, I'm in Louisiana, but moving to New Mexico. No relatives in either place. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. All right, so those are a couple of factors in this particular poster's their background. One minor child that's going to need support. They're living in Louisiana, moving to New Mexico. State law may have a little bit to do with it, but we're talking broad concepts now about probate. And the big factor was, hey, all of my relatives have money, so they could be able to take care of my kid if it takes a while. Do you want to do that? And also, are you going to be dealing with a probate court long-term for a minor child if money ends up in probate and in some kind of testamentary trust? So let's continue and see what the other members of the community are going to have to say. It all depends, of course, but generally people avoid probate to preserve the value of the estate, especially when probate attorney fees are considered. Drastically reduce the time spent in estate administration. 9 months to 2 years is common. And let me just make a point there. Yes, 9 months. I say 6 months to a year just because there are some that have been extremely simple, but those are rare exceptions. And it is just a little bit of a broader range. 6 months to a year and a half to 2 years. Look, estates going more than 2 years or even 3 years, it happens. It does. And it's not any attorney's fault. It's not even the executor's fault. Sometimes there's a combination there. A lot of times it's financial institution red tape. And one thing that I've seen with the pandemic going on, courts shutting down, and now we're at a point in the economy when this is being recorded that, quote, it's difficult to get good help. It is. And so getting stuff through the court system may be taking a little longer. Avoid publicity since most, if not all, probates are open to the public. And avoid multiple probates for each state where you owned assets. Manage inheritances for vulnerable people, say minor beneficiaries, which is what we have in this case, privately within the family as opposed to being overseen by the court. Sometimes avoiding probate is the main estate planning goal people have. Sometimes it's just a nice side benefit. Point is, if you're doing estate planning, one benefit to consider with your attorney is avoiding probate. I agree that the time savings is what's most important to me. That's the key. It's most important to him. Money is everywhere, but we only have so much time. Okay, so let's go ahead and we're just going to jump to the next comment. And this is from the poster. Thanks for the bullet point breakdown. Makes sense. I have a meeting with my attorney scheduled for next week, so it's helpful to have this framework in mind. Good. This is the start of it. It's the actual framework. Now, I kind of lay out the different thoughts and considerations in my book, Estate Planning Basics, which is also in the audio book that I have posted, and there's going to be a link in the description below, that runs through analyzing these things. So this might be a good point to put in what I call the 4 big downsides of probate. 1, it's expensive. It can be anywhere from 4 to 10% of an estate gets eaten up, a lot of it by attorney's fees. Second big downside, 6 months to a year and a half or 2 years or more for probate to finish out, and people's lives end up being a little bit kind of on hold. And if it's a full-blown probate, meaning it's not, okay, I've got a trust and there were 1 or 2 items that ended up having to go through probate because they weren't titled properly. If it's a full-blown probate, I say this could be the worst part-time job you'll ever have, is being an executor, and that's what you would be putting on your executor. Third big downside, it's easier to contest a will as opposed to a trust because the probate court system is set up for people to just file a challenge and go for it. And a lot of times, depending on the state, a lot of times the attorneys get paid out of the estate no matter what. So even, I'm not going to say it's frivolous, it was just very, very not likely to succeed. Attorneys will take a shot and go ahead and do it anyway. And so that just drags out the time and the expense, and a lot more than we'd like to think. People get paid to go away and settle this thing out, but that's the vulnerability of probate. If you're trying to contest a trust, you're actually suing the trust, and you got to come up with your own money to pay the attorneys to push that. And the fourth downside is privacy. There is a lack of privacy for the estate in that everything that goes into probate, and I'm speaking now mainly of North Carolina, but it's pretty much the same everywhere. Anyone can get those filings because it's a public document, and you can see exactly what the assets are and what they were worth at the time of that filing. All that money's there, along with often names and addresses and ages of the beneficiaries, so people can fill out their marketing lists. All right, so let's continue on with the advice being given. Really depends. In my region, most estate planners charge somewhere in the $2,000 to $3,000 range for a simple trust-based estate plan. Without the plan, the client's probate estate may take 30 to 40 hours of legal work at, say, $300 an hour, which comes out to about $9,000 to $12,000 in legal fees. This has got to be very regionally dependent. The legal fees associated with trust administration, on the other hand, can range a ton, but in a simple plan as described above, the cost would generally be insignificant, and the plan overall would likely save you anywhere from $5,000 to $10,000 in legal fees. But it's really hard to speak about this type of thing in generalities. Costs can vary dramatically depending on the facts and circumstances. All right, and let me also add, it can vary significantly depending on the type of trust and the plan being put together. I've been doing this a long time, and I only use the top of the line, best thorough plans that can cover tons of contingencies just to make sure. I've seen when some kind of complication comes up with a, quote, simple trust, and it just can end up being disastrous. And the quickest and easiest example is if it's a very simple trust and it doesn't really provide any protections and shields. If a beneficiary becomes disabled, they could end up losing their benefits because, oh, well, it was a simple trust. That language wasn't there. No, we make sure that it's covered. So let's continue and see what else the community has to say. I was a probate attorney for almost 20 years. I agree with the poster who says it has changed a lot for the better. Okay, I'm going to have some comments on this one. For most estates, I would go to court twice. Once to open the estate and once to close it. Probably 5 to 10 hours of court time and related time. Preparing notices on average. This was in Cook County, Illinois, a place not known for efficiency. The problem comes with comparing apples to apples. If you need probate, your family will require professional advisors to help with that when you die. And here's the thing. If you don't need probate, your family will also require professional advisors to help with that when you die. The court part of the equation is or can be fairly small. The time-consuming parts of post-death administration involve retitling, collecting assets, and filing taxes. That stuff is needed for every estate. I would add that avoiding probate may be a good idea if you have a simple estate where people get along, but opening a probate can be beneficial if this isn't the case. Like if someone is disinherited or there could be claims filed against your estate. In those situations, opening probate can start the statute of limitations or can help avoid family fights by making sure formalities like notices are observed. All right, I am going to disagree 1,000% with this. And it's from this perspective of attorneys, because attorneys often talk with attorneys when attorneys are comparing, oh, it's not like it used to be. I'm questioning a little bit those time estimates. It's been, in my experience, a lot more. And it drags on. And it keeps going. Whatever the attorney time is there also paralegal time or assistant time? There's the delays in court and this whole thing just going on. And well, they focused mainly on cost. But I had a discussion with an attorney who was a divorce lawyer and talked about, okay, well, when I talked with this client and there was these special circumstances, the ex-husband was selling drugs. There were, he was high all the time. There was all of this other stuff. And I talked and mentioned how, look, we were naming guardians. We weren't naming that ex-husband. So automatically there's this presumption that the other biological parent's going to be good, but you can overcome that presumption and try to do whatever you can to get custody and guardianship over to someone else. And so I said, we kind of built a packet of here's all the things and document. And, oh, well, why would you do that? And it was like, well, because you want that proof. You want that to go to the court. Oh, well, look, I can't imagine that a judge would do that if you just mentioned that other stuff. Well, I'm like, but judges are elected, and we've got some pretty out there judges who, well, oh, it's the family. You got to give it to the family. Even if these other things are alleged, there's no documentation. And they said, well, I suppose that gives you something to appeal. Appeal? You're talking about appealing a guardianship? This could take a year. A year that your kid is living with a drug dealer, even if it was the father. The attorney didn't get that the family didn't want to go through it because they were so used to going through the court process. But why would you put a family through that unless it was more about the attorney getting paid? The other thing is, oh, well, if it's a simple probate where everybody gets along, then maybe use a trust. to avoid probate. But if people are going to fight, and you put it into court instead of in a solid trust with arbitration provisions and clauses that will disinherit them if they contest it, that's the exact opposite. Why would you ever want a court and its expensive process to be part of this? No. Totally disagreeing with that thought and that line of thinking on all of that. All right, so let's see what some other people had to say. Really interesting insights here, thanks. And then Exton Guy, a frequent poster. Personally, when I set up my trust, I was thinking of it and when I might become incompetent. That's another thing. Relatively easy for my successor trustee to take over. Second thought was speed of administration after I die. My beneficiaries would have a hard time waiting several months. All right, so that's another thing. It's what if you become incapacitated? It's been called this whole conservatorship that would end up taking over. It's a court supervising everything. I've heard it called living probate, and that's pretty darn accurate. So let's go ahead and get some more comments and insights. There are 3 main reasons why using a trust to avoid probate is better. It costs less. Probate involves court fees, relatively small executor fees, and attorney's fees. These can add up quite a bit, and a typical range is 3 to 8%. Well, like I said, 4 to 10% seems to be a little more just in my experience, but this could be exactly where in this attorney's experience, 3 to 8%. Okay, it takes less time. Probate requires a creditor notice period, which I believe ranges from 3 to 9 months, depending on the state, 4 months in New Mexico. A trust is typically administered within 90 days. Third, privacy. Probate is a court procedure and court records are open to the public. Some states will keep some records private, but not everything. Even worse, if there are children or disabled beneficiaries involved, the court may supervise the matter for years to come. Now, that's really in line with what I called the 4 big downsides. The only one that was left out was it's easier to contest, but okay, that's some pretty solid reasons. Let's go ahead and check out a few more. My father died without a will. He had a small life insurance policy, some debts, and no other assets. I have 2 sisters, and he had a stepdaughter. Her mother, his wife, had predeceased him. His estate took 2 years to settle. Like I said, it could take quite a while. It was completely uncontested and with virtually no assets. My husband and I have significant assets, and we ran to an estate planning attorney after the experience with my father's estates. We also have spent the last 2 years strongly encouraging our parents and my siblings to do the same, which they all finally have. I never want to go through the experience of dealing with an estate through the probate process again. By the time I was done, I realized that it was A, unrealistic, and B, kind of crappy to assume your heirs will just figure stuff out amongst themselves, and deal with the process. Err on the side of planning. It's an ironic statement, but it gives everyone more agency over their own estate, and it can avoid a lot of fighting over finances and assets, and it can save time. In the original poster, appreciate the perspective, especially since you're in a financial situation similar to what I'm expecting out of anyone handling my estate. Okay, so yeah, it their experience, it was crappy of someone to just dump it on the family and say, okay, here you go, figure it out. It really did put a burden on the family, whereas with the trust, it can be a lot more smoothly done. Let's keep going. Keep in mind that one does not really need a trust-based estate plan to avoid probate as long as all your assets can be titled to bypass the estate and you keep estate assets below some amount. Estate attorneys push trust-based estate plans, and probably for good reasons, but in many cases there are alternatives. Okay, alternatives that I call duct tape planning. Kind of good for one shot. On the flip side, there are certain assets that have to go through probate. This is why we all need good estate attorneys. The other reason is if you're married and live in a state with a fairly low estate tax zero bracket or are quite wealthy, you can effectively double the zero bracket by placing half the assets into a bypass trust so the spouse never owns them but has benefit of them. So there are estate tax reasons too, though not explicitly probate related. Okay. So they're talking about a bypass, a credit shelter trust. Look, that could be a whole other topic on its own. We're not going to go through that right now. But that is if you've got significant assets, that could be a big thing. Let's continue. I think we just have a few more. The original, or this is it, the original poster, understood. And yeah, I know at the end of the day, this will be highly fact specific. In my own case, I own a couple of businesses, property in another state, etc. So when I meet with my attorney at the end of the day, it will be about digging into these facts. This is all very helpful for framing the general pros and cons, though. Good. The fact that he's going to have real estate in another state opens a whole other thing, because now you would need ancillary probate. Now, let me tell you how it works in North Carolina. It may be different state to state, but the fact is, if you've got real estate in another state other than the one where your main probate is, which is typically wherever your residence is, your primary residence, if you have property in another state, you need to have an ancillary probate proceeding. So it's not even dealing with the same court where you lived and you died. It's dealing with another court to transfer the title either into the estate or into the beneficiaries, and it's being governed by that court in another state. So where I am in Raleigh, North Carolina, sometimes I have clients, oh yeah, we've got a townhouse in Virginia. Williamsburg, Virginia is a big kind of tourist attraction. Busch Gardens is there and everything. And we also have a condo in Myrtle Beach. All right, you're going to have main probate in Raleigh, North Carolina, in Wake County, and then you're going to have a probate proceeding in Virginia and another one in South Carolina to coordinate this. If you moved the real estate into the trust, you don't have to deal with probate in 2 other states. So coordinating all of this through a revocable living trust often makes sense to avoid all of those complications and expenses. All right, so I hope you found that information useful. Check out the links in the description below and to see some of these resources, a lot of free downloads and other stuff like that, free webinars. Check it out. If you're starting your estate planning journey, get the right information to see how things are going to be so you can make the best decision for you and your family. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.